Georgia is a state that surprises a lot of people when it comes to habitability law, because for decades, Georgia was one of the few states that did not recognize the implied warranty of habitability at all. That changed, but the state still operates with one of the most landlord-friendly frameworks in the country. If you manage rental property in Georgia, here's what you need to know. Georgia does not have a comprehensive residential landlord-tenant act comparable to what you'd find in most other states. The state's landlord-tenant provisions are scattered across several sections of the Georgia Code, primarily in Title 44, Chapter 7. And for a long time, the prevailing legal doctrine in Georgia was caveat emptor, let the buyer beware, meaning tenants essentially took the property as they found it. That said, Georgia has evolved. The state now recognizes that landlords have a duty to maintain rental property in compliance with applicable building codes and to keep the property in a condition that does not endanger the health, safety, or well-being of tenants. Georgia Code Section 44-7-13 requires landlords to make repairs to keep the premises in the condition they were in at the beginning of the tenancy and to comply with all applicable building and housing codes. Under Georgia law, landlords must keep the structure sound and weathertight, maintain plumbing and sewage systems in working condition, ensure electrical systems are safe, provide adequate heating, keep the property free from conditions that create a substantial risk to health or safety, and comply with local building, housing, and health codes where they exist. Now, here's where Georgia gets complicated. The state's habitability protections are significantly weaker than most other states in terms of tenant remedies. Georgia does not have a statutory rent withholding remedy. There is no codified repair and deduct process, and there is no formal rent escrow system at the state level. This means that if a landlord fails to maintain the property, a Georgia tenant's primary options are to pursue the issue through the courts or to contact local code enforcement. The court route typically involves filing a lawsuit for breach of the landlord's duty to maintain the property, seeking damages, or arguing constructive eviction if conditions are severe enough that the property is essentially unlivable. Constructive eviction requires the tenant to actually vacate the premises, which is a significant step, especially in Georgia's tight rental markets where finding alternative housing quickly isn't always easy. Local code enforcement is the more practical remedy for many Georgia tenants. Cities like Atlanta, Savannah, Augusta, and Columbus have their own housing codes and inspection departments that can investigate complaints, issue citations, and order landlords to make repairs. Atlanta in particular has an active code enforcement division that handles rental housing complaints. Atlanta deserves special mention because the city has been working to strengthen tenant protections beyond what state law provides. The city's housing code is more detailed than the state framework, and Atlanta's code enforcement has become more aggressive in recent years in addressing substandard rental housing. Landlords with properties in Atlanta should familiarize themselves with the city's specific requirements. Georgia's climate creates specific maintenance concerns. The hot and humid summers promote mold growth, especially in older properties with poor ventilation. Termites are a major issue across the state. Georgia is in the heavy termite activity zone, and ongoing prevention is essential. And while winters are milder than northern states, heating systems still need to be functional, particularly in the northern part of the state, where temperatures can drop below freezing for extended periods. One important Georgia statute that landlords need to know is the requirement regarding carbon monoxide detectors. Georgia law requires carbon monoxide detectors in residential units that have fossil fuel burning heaters or appliances, a fireplace, or an attached garage. The landlord must install the detector, and the tenant is responsible for maintaining it. Failure to install one creates liability. Georgia also has a specific statute regarding landlord liability for criminal acts on the property. Under Georgia Code Section 44-7-14, landlords have a duty to exercise ordinary care to keep common areas safe. This includes adequate lighting, functioning locks, and addressing known security concerns. While this isn't strictly a habitability issue, it overlaps significantly with the duty to maintain safe conditions. Georgia's anti-retaliation protections are limited. The state does not have a broad anti-retaliation statute comparable to what you'd find in more tenant-protective states. Some Georgia courts have recognized retaliatory eviction as a defense in certain circumstances, but the protections are far less developed than in states with specific retaliation statutes. The practical takeaway for Georgia landlords: while the state gives you more legal flexibility than most, that doesn't mean you should cut corners on maintenance. Code enforcement is becoming more active, tenants are becoming more informed, and a property that falls into disrepair will cost you more in the long run through vacancies, legal disputes, and damage than proactive maintenance ever would. For the complete guide to Georgia habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.